In 1853, the United States Supreme Court decided a patent dispute that still shapes technology law today. The inventor of the Morse telegraph tried to claim ownership not just of his machine, but of the entire concept of using electricity to transmit written information at any distance, by any method, invented by anyone. The court ruled against him. That decision became one of the most cited principles in American patent history, and it took a years-long commercial war between two extremely stubborn men to get it there. Samuel Morse was a professional portrait painter before he became an inventor. He trained at the Royal Academy in London and spent his early career painting wealthy American clients. He had no formal training in engineering or physical science. In 1832, on a ship returning from Europe, Morse heard a fellow passenger describe recent experiments in electromagnetism. He began sketching ideas in his notebook for a device that can use electrical signals to transmit information. The concept was not new. European inventors had already been experimenting with various forms of electrical telegraphy for years, but Morse pursued a practical, commercial version with single-minded focus. His development of the telegraph depended substantially on the prior work of Joseph Henry, an American physicist who had already demonstrated key electromagnetic principles that made the device possible. Henry provided Morse with direct advice and technical knowledge. Morse acknowledged this during development, but spent much of his later career minimizing Henry's contribution and asserting sole credit for the invention. Henry disputed this publicly, and the argument between them was a running controversy for decades. By 1837, Morse had a working prototype. By 1844, he had secured government funding to build a demonstration line between Washington and Baltimore. On May the 24th of that year, he transmitted the message, "What hath God wrought?" a phrase from the Book of Numbers chosen by Annie Ellsworth, the daughter of the Commissioner of Patents. The commercial impact of the telegraph was rapid and significant. News, financial prices, government communications, military orders, all of it could now move in seconds rather than days. Telegraph companies expanded quickly, competing for routes and customers across a growing national network. Morse held patents on the technology and collected licensing fees from operators. He was, by the late 1840s, both famous and wealthy. Morse filed patents aggressively and fought to enforce them. Patent number 6973, first granted in 1840 and substantially expanded on reissue in 1846, contained 8 separate claims. 7 of them covered his specific equipment and methods, the arrangement of the electromagnets, the recording mechanism, the code of dots and dashes, the particular way signals were sent and received. These claims were contested at the margins but were broadly recognized as legitimate descriptions of a real invention. Claim 8 was categorically different. It read, Morse claimed exclusive rights to the use of electromagnetism, however developed, for the purpose of printing intelligible characters, signs or letters at any distances. The phrase "however developed" is the critical one. Morse was not describing his specific machine or any particular implementation. He was claiming all implementations. Any device built by any person, using any arrangement of components that used electromagnetism to transmit text across a distance, all of it fell under Claim 8. A competitor could design a telegraph that shared nothing with Morse's machine except the underlying use of electrical current, and under Claim 8, they would still owe Morse. The argument for this position was that the conceptual breakthrough was the invention. Nobody had built an electrical telegraph before Morse demonstrated it was possible. Every telegraph that followed depended on that demonstration. Morse's supporters argued he deserved to profit from the full scope of what he had made possible. The argument against was that Claim 8 was not a description of an invention at all. It was a description of a natural phenomenon, electromagnetism combined with a desired outcome, text transmission at a distance. Electromagnetism is not something Morse discovered. It existed long before him and was already well documented by scientists, including Henry Oersted, André-Marie Ampère, and Michael Faraday. Morse had found one way to use it. He was now claiming the right to control every possible use of it in the field of communication. Henry O'Reilly, who also spelled his name O'Reilly in various documents, was an Irish-born journalist and political organizer. He had been involved in Democratic Party politics in New York, served as postmaster of Rochester, and had a long record of writing combative public pamphlets on issues he cared about. He was not someone who avoided confrontation. In 1845, O'Reilly signed a contract with the Morse patent holders, specifically with Amos Kendall, who managed Morse's business interests, to build telegraph lines westward from Philadelphia across the American interior. The contract gave O'Reilly the right to build and operate lines in specified territories in exchange for a share of revenues and compliance with the Morse patent terms. O'Reilly was effective at the construction side of the business. He raised capital, organized work crews, negotiated with local governments and landowners, and pushed lines through quickly. He reached Pittsburgh, then Cincinnati, then Louisville. He was genuinely expanding the telegraph network into regions Morse's own organization had not reached. The relationship broke down in 1847. Both sides accused the other of violating the contract. Kendall and the Morse Group claimed O'Reilly had exceeded his territorial rights and failed to comply with patent terms. O'Reilly claimed the Morse Group had acted in bad faith, blocked his expansion into profitable markets, and manipulated the contract terms against him. The specific facts were disputed then and remain disputed by historians. What is clear is that by the end of 1847, the two sides were in open legal conflict. O'Reilly responded by continuing to build telegraph lines using equipment that did not use Morse's specific technology. He adopted the printing telegraph designed by Royal Earl House, an inventor from Vermont whose system used a piano-style keyboard and a type wheel to print letters directly rather than using Morse code. The House Telegraph was mechanically distinct from Morse's system in almost every respect. Morse's legal team argued the distinction was irrelevant. The House Telegraph used electromagnetism to transmit characters at a distance. Under Claim 8, that made it Morse's property regardless of the mechanical differences. Litigation spread across multiple jurisdictions. Cases were filed in federal courts in several states. O'Reilly countersued on multiple grounds. He also waged a public campaign, writing letters to newspapers and publishing pamphlets arguing that Morse was using his patents to shut down legitimate competition and centralize control of the telegraph industry in the hands of a small group of investors. The case became a national story. Newspapers that relied on telegraph news had a direct financial interest in the outcome and covered it accordingly. By the early 1850s, the core legal question whether Claim 8 was valid had worked its way toward the Supreme Court. The case was decided by a court led by Chief Justice Roger Taney. Taney is best known today for the Dred Scott decision of 1857, which is widely regarded as one of the worst rulings in Supreme Court history. On the patent question before him in 1853, however, the court's reasoning was considerably more sound and has remained influential ever since. Morse's legal argument was essentially that the scope of the invention justified the scope of the claim. Without the foundational insight that electromagnetism could be used to transmit written communication, none of the subsequent development would have occurred. A narrow patent that only covered Morse's specific machine would be commercially worthless because competitors could simply redesign the hardware while using the same underlying principle. The only meaningful protection was a claim broad enough to cover all electrical telegraphy. O'Reilly's lawyers attacked Claim 8 on a specific legal basis. It did not describe an invention. Patent law requires that a patent claim describe something the inventor actually made or specifically conceived. Claim 8 described no machine, no process, no specific method. It described a desired result, text transmitted electrically at a distance, and claimed ownership of every possible means of achieving that result, including means that did not yet exist and that Morse had never conceived of. That was not a patent. It was an attempt to claim ownership of a natural force. The court ruled 7-2 that Claim 8 was invalid. 6 of Morse's remaining 7 claims were upheld. Taney's majority opinion drew a clear line. Morse had the right to patent his specific telegraph, the described machine and its described methods of operation. He did not have the right to claim all uses of electromagnetism for text transmission. Electromagnetism is a natural phenomenon. It was not invented by Morse, and its existence is not the result of any human act. A person who discovers a new use for a natural force does not thereby acquire the right to prevent all other uses of that force in the same general area. Taney also addressed the practical danger directly. If Claim 8 were upheld, no one could ever build any kind of electrical telegraph without Morse's permission, regardless of how different their technology was. That would give one patent holder permanent control over an entire technology sector, not because of what he invented, but because of what exists in nature. The patent system is meant to reward specific inventions by giving inventors a temporary monopoly on what they actually build. It is not meant to let someone stake out an entire technological domain. Morse died in 1872, still disputing the fairness of the ruling on Claim 8. He continued to argue in writing and in court that the decision had denied him legitimate compensation. His position had some internal logic. The question of how broadly to protect foundational inventions is genuinely difficult, and courts have not always answered it consistently, but it never prevailed. O'Reilly continued operating telegraph businesses, but never built the commercial empire he had envisioned. Western Union, formed in 1851 and expanding rapidly through the 1850s, gradually acquired or outcompeted most rival telegraph operations. Neither Morse nor O'Reilly ended up controlling the industry they had fought over. The legal principle established in the case, however, became permanent American law. O'Reilly versus Morse is the origin of the rule that laws of nature, natural phenomena, and abstract ideas are not eligible for patent protection. Courts have applied this rule across more than a century and a half of technological change. In 2013, the Supreme Court cited O'Reilly versus Morse directly, an association for molecular pathology versus myriad genetics. The case concerned whether a company could patent human gene sequences it had identified and isolated. The court ruled it could not. Naturally occurring DNA exists independently of any human act. Identifying its location and isolating it for study does not constitute inventing it. The same principle Taney applied to electromagnetism in 1853 applied to genetics 160 years later. The same question comes up repeatedly in software patent disputes. Courts distinguish between a specific technical implementation, which is patentable, and a mathematical algorithm or abstract computational method, which is not. The line between the two is disputed in almost every major technology patent case, but the existence of the line and the principle that abstract ideas and natural phenomena sit on the unpatentable side of it derives from the Morse ruling. The outcome of O'Reilly versus Morse established a constraint that has applied to every major technology wave since: electrical, chemical, biological, digital. No single inventor or company can own a law of nature or a natural phenomenon, regardless of whether they were the first to find a use for it. That rule has real consequences for competition and innovation. If Claim 8 had been upheld, it would have established a precedent that foundational technology can be monopolized at the level of principle rather than at the level of specific implementation. Every subsequent inventor working in any related field would have needed to negotiate with the original patent holder rather than simply build something better. The court decided in 1853 that this was not what patent law was for. Morse's specific telegraph was protected. The underlying science was not. That distinction remains in force today. If you enjoyed this video, subscribe so you'll never miss another episode.